Utah versus Brian Sondrup. I have one matter today set for competency hearing in case ending, let's see, 9980, and it looks like we have Ms. Leach present from Utah State Hospital's attorney, and who's counsel for the state? Mr. Bean.
Yes.
Yeah. And Mr. Sondrup's here in person?
He is.
Okay. Welcome, Mr. Sondrup. How are you?
Good. Thank you, Your Honor. Thank you for your time and grace today.
Good. It looks like I received a letter from DHHS.
Your Honor, before we begin, I wanted to let you know that
Hang
I'm
on.
firing Mr.
Let your attorney, hang on just a second, okay?
Thank you. I apologize.
All right.
I'm just no longer want Tyler to actually represent me.
All right, we'll address that in a minute.
Thank you.
Mr. Needham, let me hear from you first.
So, Judge, we did have a private competency evaluation done. Its result was the same as Dr. Rubenzer's. So at this time, I am not challenging Mr. Sondrup's competency to stand trial.
All right, then if you'll prepare as a state, I guess.
No, I was just standing.
Are you in agreement with the competency finding?
Yes.
All right. Then, Mr. Needham, if you'll prepare those findings for my signature, the court will adopt the findings of competency. We'll transfer his custody status back to the jail. I assume he's been at the Utah State Hospital still.
That's correct.
We'll transfer his custody status back to the jail. And then how do you want to proceed?
I mean, the plan was to set a pretrial conference and see where we're at, but I think Mr. Sondrup might have something to address with the court.
All right, Mr. Sondrup, go ahead. Mr. Bean, did you have something you want to add?
Your Honor, the state would actually ask to set this for trial. This has been going on for some time, and the state is wanting to move this along. So,
Well, with the motion that Mr. Sondrup has just made, I'm not sure that we can do that quite yet. So let me hear from Mr. Sondrup.
Your Honor, first and foremost, thank you. My voice has been suppressed for the last 25 months. I thoroughly honor your graceful time today. So thank you for that, first and foremost. I just want to simply address that we are sui juris, living flesh and blood man of the Sondrup Nation, one of the people. We are here by way of special visitation only. We are not surety for the accused, all caps, dead legal fiction, name of our namesake, of our public charitable trust. We are here from threat, duress, coercion, manipulation, intimidation, vexatious litigation, malicious malfeasance, dereliction of duty, intention to cause fraud, conspiracy to deprive, false arrest, false imprisonment, deprivation of rights, defamation of character, loss of goods and services, and intentional malpractice. We are not pro se, and we do not pay homage to the British Credit Registry. We rescind, reject, rebut, and revoke all prior proceedings and invoke the common law. We do not understand these charges but send over these charges. We put forth for the record and on the record an official plea of demurrer and remind the courts that we are sui juris, living flesh and blood man of the Sondrup Nation, one of the people. We are here by way of special visitation only. We have not been logically or rationally able to communicate in a reasonable degree with all counsel and assert for the record and on the record that we do not consent to contract. All prior counsel has actively been involved in collusion and hiding exculpatory evidence, and I believe firmly that there is something further within this conspiracy. So thank you for allowing me to have the time to make that declaration to you. Like I said, I just believe that I have not been logically or rationally able to communicate with a reasonable degree ever with my counsel, and I can't trust them. I feel like there's bias and prejudice, and there's not anyone who would be willing to help me.
Are you seeking new counsel, or are you going to hire your own counsel?
At this moment, I am sui juris, and I will be moving forward with self-representation.
Before we get to that point, I'll grant the motion to withdraw that I assume is forthcoming from you, Mr. Needham, given that information.
I think given that, that's the only thing I can do at this point.
And Mr. Sondrup, I have to go through a colloquy with you before you can make the determination that you want to represent yourself. You're being charged today with 7 first-degree felonies. I advise you that representing yourself when you're being charged with anything in court, let alone the highest, almost the highest degree of offenses that you can be charged with. It would be like going into brain surgery without a brain surgeon and deciding you're going to do that surgery yourself. Even if I, having been an attorney, were to be charged, it would be against anyone's better judgment to let me represent myself. I would have an attorney represent me. That is how important I think having an attorney represent you is. That is even more important in cases like this, where you're facing the rest of your life in prison if you're convicted. Certainly, I would hope that you would see the benefit to having someone who is trained in the law represent you in a case of this nature.
Your Honor, I feel like I've just been forced and pressured to have representation that has no interest in helping me, but they're colluding and doing the opposite and actually actively going out of their way to conspire against me to find ways to hide exculpatory evidence and to not actually help me at all. So I absolutely appreciate the sentiment and the recommendation. I just feel that at this point I would prefer, like I said, to proclaim that I am not pro se and that I will not be forced or pressured to have representation from the courts.
So we have just resolved the issue of competency. He's been found competent now by 2 doctors who have evaluated him. The next question for you, or really I guess the next thing I need to tell you, is that anything you say in this hearing can be used against you. And so I don't want you to say anything about the offense to which you have been charged, but I have to ask you some questions. So have you ever studied the law at a law school?
No, Your Honor.
Do you know the rules of criminal procedure?
No, Your Honor.
Do you know the rules of evidence?
No, Your Honor.
Have you ever represented yourself in another criminal action?
No, Your Honor.
Do you understand the maximum and minimum penalties for the charges of which you face?
No, Your Honor.
You understand that you're being charged with offenses to which you could serve the rest of your life in prison on each count?
No, Your Honor.
Do you understand that this court could run these charges consecutively to each other? So meaning one right after the other.
I don't understand that.
Do you understand that if you represent yourself, you are on your own and I cannot provide any guidance as to how you proceed with trial. The state can't provide any guidance. No one can help you if you choose to represent yourself in this case. In other words, you'll be held to the same standard as if you had gone to law school and practiced law for many years to be competent to handle a case of this nature. You'll be held to that same standard. Do you understand that?
No, I don't really understand, Your Honor.
All right. So if there is an objection to be made, you would have to be able to adequately state the objection and the basis for the objection. The court could not do that for you. Do you understand that?
Not really, no.
All right. You've indicated that you're not familiar with any of the rules of evidence or any of the rules of criminal procedure. Are you aware of how a jury trial is run?
No.
Do you understand how you even pick a jury?
I have ideas, but I'm not sure, Your Honor.
You understand that if you were to represent yourself, you would have to take the witness stand and you would have to question yourself as if you are the attorney and the witness if you decided to take the stand.
I don't understand that.
And I've already told you my opinion with regard to how important it is to have an attorney to represent you. Are you making this decision of your own free will to represent yourself?
I think it's in my best interest that I'm not getting any help from anyone. Attorneys, I've had the prior counsel I was for 14 months and didn't help me. I've seen the same pattern again with this counsel. I just personally don't believe that any lawyer has my best interests.
Well, I can tell you that Mr. Needham is a very good attorney who is representing you to the best of his abilities. I would be willing to give you one other opportunity to have a new change in counsel, after that, I would not give you another opportunity because you're entitled to counsel and competent counsel, but you're not entitled to counsel of your choice. Would you like an opportunity to meet with one other attorney to represent you?
May I leave that option open?
Well, we need a decision today so that we can decide how to move forward today.
I agree that, like I said, I just don't feel like anyone has my best interests.
So it sounds like you have some trust issues with regard to your attorney, but maybe let's try a different attorney.
I think that's a pattern with all of them. I thought Mr. Needham was a great guy, but it seemed patterns just felt the same way with the last. And that they don't have interest to help me.
And so you'd rather go at it all by yourself without any knowledge of the law?
Unfortunately, that's being stuck between a rock and a hard place. That's where I feel I'm at.
And help me understand the rationale where you haven't met the next attorney who could potentially represent you, and yet you're making a blanket statement against all attorneys.
I just feel, Your Honor, that I've been giving everyone enough chance so far, and the pattern seems to be the same.
And so based on that, you are making a voluntary choice to represent yourself in these cases.
I don't know how to answer that, Your Honor.
Well, I need you to answer it in order to make a decision as to whether I let you represent yourself or whether I appoint counsel.
Like I said, I don't feel like these people are here to help me.
So are you making a knowing and voluntary decision? Are you doing it of your own free will to ask to represent yourself? Is that really what you want to do today? Is you really want to go at this without an attorney?
I'm not sure how to answer that question or how I can say yes or no.
Well, without a definitive answer on that, I'm going to appoint counsel to represent you. We'll appoint conflict counsel.
I would say that I do not want to have counsel appointed.
So you're making a decision
lack of trust.
That you want to represent yourself. That's what you want to do in this case. Knowing all of the downfalls, all of the concerns the court has, the potential maximum possible penalties, the fact that you're going to be held to the same standard, you want to represent yourself. That's what you want to do.
I don't want representation.
Okay, answer my question though. Do you want to represent yourself? Is that what you want to do today?
Yes, Your Honor.
Based on that, I find that the defendant has knowingly and voluntarily waived his right to counsel. I will permit him to represent himself. I'm going to appoint standby counsel to assist the defendant, given the fact that these are all first-degree felony charges.
Your Honor, what does standby counsel mean?
It's someone who is there that can potentially answer some questions for you during trial and during the hearings.
Okay, thank you for answering that.
Let's set this out. November 6th at 2 o'clock. Is that enough time to get new counsel to conflict it out, Mr. Needham, do you think?
The state's understanding isn't that's doable.
30 days should be enough time to at least get someone selected. They won't be able to be up to date on the case.
They won't be able to be up to date. I realize that, but at least we can make sure we have someone in place and they can meet 2 o'clock. Yes.
Your Honor, do I have the right to choose my standby counsel?
You do not, unless you want to hire them, and then you have the absolute right to choose who it is.
Okay. Thank you for answering, but how do I go about that process? Hiring them, then they just notify you or the clerk?
If you decide to hire an attorney, they would file an appearance of counsel after they got paid.
Same way with your first attorney. Like you would go hire them, you'd pay them money, retainer, and then they would file an appearance. Otherwise, what's going to happen is standby counsel is going to be not someone from my office, but someone from another list of attorneys that has a contract. One of those people would be appointed to be standby counsel for you. You would not be paying them. It would be essentially a public defender as standby counsel. But if you wanted to hire someone, you'd have to go that normal route of paying that person.
And what are their credentials?
They're all lawyers that went to law school.
They're lawyers,
We're
okay.
admitted to the Utah State Bar. They're all practicing attorneys.
Okay, understood.
All right, we'll see you back then.
Okay, thank you, Your Honor.
Thank you.